Hello, everybody. Welcome to another episode of Business of Comics. Today is episode 3, and we're going to go over trademarks and copyrights. Um, just learning the rules about intellectual properties and whatnot. And before we get started, if you're watching this on YouTube, make sure you subscribe to the channel. It helps me out. Make sure you like the video, share the video, and leave a comment in the comment section. And I'm just trying to get my notes together. As always, I try to do this like the King Kel show. Instead of just teaching, I'm going to teach as I put together the actual presentation, because I feel like it's a better way for you to learn, because instead of me just spouting out the information, it's like, oh, we're doing it together. Plus, I just think it's easier for me to record while I'm doing it. So I'm going to share the screen. So as I said, we're Business of Comics, Trademarks, and Copyrights. So let's talk about what intellectual property is. So there's two ways to protect your intellectual property. The first way is trademarks. And here it protects the concept, name, and logo of an intellectual property. So for example, we have Marvel Comics, which is a publishing company that publishes mostly superhero comics. That is their concept. And they have their characters such as Spider-Man and Wolverine, X-Men, all the characters essentially. And those characters are protected under the trademark. So you are not allowed to use the name Spider-Man as a way to sell your product, or comic in this case. Now, you can have a character named Spider-Man, but they cannot have a costume that is similar to Spider-Man. They can't be named Peter Parker. They can't have web shooters. They can't, you pretty much get the gist. So if you want a character who has spider-like powers, you can do that, and you can call them Spider-Man, you can call them Spider-Woman. You just can't sell your property as Spider-Man, and it cannot look like Spider-Man or have the same history as Spider-Man, and so on and so forth. Now, there is ways around that, apparently. You can do something that is called a satire, and which is where you kind of make fun of the original material. If you think about Weird Al Yankovic, that's pretty much what he did with music videos. So the same thing can be done in that regard, but that's out the scope of this video. I just wanted to throw it out there. So moving on, we have copyrights. And copyrights protect the story, script, and visual artistic representation. That includes the pencils, the inks, the colors, the lettering. All right. And for example, we have Uncanny X-Men Volume 1, Issue 316. The story and script was written by Scott Lobdell, the art by Joe Madureira, and the characters were created by the characters that would go on to be in Generation X were created by Scott Lobdell. Characters like Banshee and White Queen were already created. I didn't go to see who actually created them, but regardless of who created them, everything belongs to Marvel as far as the copyright. And this will be something that we'll discuss later that is called a work for hire, which is what allows Marvel to keep ownership of the copyright and the characters, and does not give the right Scott Lobdell and Joe Madureira still get credited as the writer and artist, but they do not have any rights to the story or the art themselves. Um, Again, I'm sure they have some kind of thing, something in their contracts where Scott probably is allowed to use the script in like his portfolio or on his website or something like that. If he's teaching, I'm sure Joe Madureira is able to use the art in his portfolio as well and probably sell it. They probably, and those are like finer details of their particular contracts, because at the time of when this issue was released, Scott Lobdell was like one of the hottest writers in comics, and Joe Madureira was an up and coming artist who was taking the industry by storm. So they probably have something special where they have that worked out. And again, that's a little more out the scope of what we're going to talk about today. But again, I just wanted to make you aware that there are ways to structure the copyright as to who can do what with the material. So let's go on and create our next slide. So let's talk about how to obtain the protection. So for trademarks, there are several ways that you can do it. The way that I'm doing it for the logo that you see that I use for my company is I went through LegalZoom. And they have, they give you a chance to look up trademarks to make sure that to make sure that your logo is not already similar to somebody else's. Now, the other way to obtain it is to go through a law firm. Preferably one that specializes in intellectual property. Now, if we go to LegalZoom, and type in intellectual property, let's see, you will see, we'll click there and we'll probably take it. Trade, and you go to search the trademark, and it comes up right away, register the trademark. And if you do it yourself, it's $249 plus federal filing fees. Or you can let an attorney take the lead. This will be $600. So it can get pretty pricey. Again, I'm doing it myself. I probably use my credit card, my business credit card. So you know, I don't remember it being that high. But again, you want to make sure that you protect your logo because that's your brand, and your brand is how you're going to represent yourself when you go to sell your products. So the other way, going back, and so you can go through a law firm. You can also register with the United States Patent and Trademark Office, who will file the trademark for you. You, before you do your trademarks, you always want to make sure that you do a trademark search. Now, again, if you have a lawyer doing it, they'll do that for you. Legal Zoom, they do it for you, even if you do it yourself. So, but if you go through the United States Patent and Trademark Office, it seems like you have to do the trademark search yourself, which you can do on their website. For copyrights, again, you can go through LegalZoom, which I did not do. My copyright for Favor of Athena, I did myself. It's about $40, and you can do that through copyright.gov. And again, you can also go to a law firm that specializes in intellectual property. Now, there used to be a way that I haven't confirmed is still viable, but there used to be a way of copyrighting your material by mailing it to yourself. But some of the stuff I've been reading in the past 2 years or so through my college endeavors and just general research, it doesn't seem like that's really like a viable way to protect your work. But again, it used to be a way that people did. Recording. Right. Mothers. So let's talk about why. So you, like I stated earlier, you want to, I don't think we need to, you want to protect your brand and you want to protect your stories. Um, there's a lot of thieves out there, and you see it all the time in the music industry. You see it even in the film industry. I can't recall a particular case right now, but again, the first reason is protect your brand and your work. That's the first reason. The second reason is having these in place allows you to defend yourself in court in case you go to sue somebody who may be infringing upon your work. Um, there's been cases. One of the one of the more interesting cases was the creation of Venom, where Marvel had to create a character contest. And this artist, a fan, obviously, I don't know if it's in here. Let's see. Probably not. Oh, so they wanted, oh, I thought it was a creative villain contest. All right, so yeah, so the original idea for a new costume for Spider-Man was conceived by a Marvel Comics reader named Randy Schuller in 1982. Marvel basically purchased that costume for $220. And then Marvel went on to do the changes that they needed to make Venom And when Venom became popular, I believe that it's not in here, but apparently Randy did try to sue Marvel for essentially robbing him of his rights. And I don't think he won. So yeah, so as you can see here, it's still a debate. But essentially what happened is because Randy did not have the costume copyrighted, which would be hard because he would have to attach it to a character. I guess maybe he doesn't have to attach it to a character, but because it's still a Spider-Man costume, he definitely couldn't have said a costume for Spider-Man. He would have to definitely have come up with a different name for the costume itself, um, if you will. It's the same thing with fashion design. And so because he didn't have anything to protect him, Marvel was in their right to have bought the costume from him for $220. They were able to not only, so they didn't have to get a copyright, they had to get a trademark, and they were able to trademark the black costume for Spider-Man, and then they were able to trademark Venom. So it's such for Randy. It's just one of those stories that goes to show you that you don't give anything for free and or cheap value. And the weird thing about it all is that people used to do this all the time in the 80s and 90s. Part of your submission packet, if you were using original characters, that was one of the reasons why Marvel and DC used to have rules in place in their submissive guidelines, so that you can't, so like if you sent the story in and let's just say it was like Romeo and Juliet, and you sent the story in, and Marvel liked it, but didn't necessarily want to hire you, Marvel could then turn around and use that same story, but because of what I forget what it was called that you had to sign when you did your submission, but you could try to sue, and Marvel will have the right to say no. You kind of like gave that away when you submitted it to us. So these days, especially when you're an independent creator, you want to make sure that everything is protected, and so that you can control the license of it all. And we'll go over licensing later. But these are the two main reasons why you want to do it. It just gives you the ability to defend your work and your brand. So, but yeah, that's pretty much it. Let's see if I have anything else. Yeah, no, that's pretty much it. So traditionally, yeah, so traditionally, um, people used to mail it to themselves all the time, and trying to and because of certain cases, the trademark laws and copyright laws have changed over time. The biggest change was back in 1988. There was no um, adequate way of trademarking particular productions, and that was one of the big changes that happened back then. So yeah, so that is pretty much it. We went over the differences between trademark and copyrights. We went over how you can get a copyright or a trademark. And then we talked about why you need a copyright and trademark. So I know the two can be very confusing. And I'm just trying to make things easier for those of you who want to go into the comic book industry as independent creators. But this is also good information for anybody who is starting up their own business, regardless of the product or service that they're providing. Because again, even if you are a software engineer and you're starting up your own website design company, you want to get a trademark to protect your logo, or any concepts that you may come up with. Maybe you design a whole new way of designing websites. You want to make sure that you trademark that. Funny thing, games are trademarked, but the game companies cannot, I forget why, but game companies cannot trademark or copyright the mechanics of the game, or is it the rules? I think it's the mechanics. Let me double check on that. But essentially, if you wanted to make your own version of Monopoly, so long as you don't call it Monopoly, you can make Monopoly. So you just got to call it something else. Obviously, you got to change the pieces. Probably have to change the money. I would imagine you would have to change the money design and obviously the card designs, like community chess and all that good stuff. So something to think about. It's something that I'm going to be doing. I'm going to be making my own set of overpowered cards once my universe is a little more set in place. But I figured I would share that little tidbit because I remember when I learned that in my writing for games course, that blew my mind that they can't copyright the mechanics. They can only copyright the essentially the brand of the game. So I just thought that was real interesting, and you can look that up. So again, try to keep these short and sweet for you guys. That was trademark and copyrights. If you would like to talk more about it, you can email me at tjenkins@terrierjenkins.com. Make sure you write trademark and copyright info in the subject line. I will respond in time. Again, you can also check out legalzoom.com, and you can visit the trademark. Stop. Here's something up. You can visit the trademark and patent office at, I'm going to pull that out for you. At www.uspto.gov. Copyrights can be obtained at copyright.gov. And what am I legal Zoom? Let's fix that right now. There we go. Yeah, and there's plenty of other places on YouTube, or if you search Google, if you want to learn more in detail about trademarks and copyrights. So I hope that helps. And that ends our episode, everybody. Episode 3 is in the books. Again, if this was helpful to you, please hit the subscribe button, hit the bell to be notified of new videos, like the video, comment, and share the video. It helps my channel grow. And I will be back with another episode in which we'll probably go over freelancers. So until next time, be terrific.